All right, good morning, ladies and gentlemen. We are ready to get started. Hopefully we can get through all of these bills today. And Judge Scoggins, what microphone are you on? There you go.
16.
All right, do you mind opening us up today?
Yes, sir.
Thank you.
Will you bow with me, please? Our most kind and gracious Heavenly Father, thank you for the opportunity to be here today. Thank you for the opportunity to be here and do the work for the state of Georgia. We thank you for your grace and mercy every day. And we wish you would lead us and guide us through all of our decision making. And everything that we do is because of you. In God's name we pray. Amen.
All right, thank you. All right, I first of all want to recognize Representative Todd Jones, who is a lawyer and attending the committee meeting today.
Thank you.
But I want everybody to know he is a lawyer. He can practice law if he wants to. All right, I beat up on him enough.
Thank you, Judge.
All right, Representative Reeves, we're going to start with House Bill 270. If you don't mind, give us the rundown on that.
Governor and members of the committee and Representative Jones. House Bill 270. Let me relieve anybody who's here from the aviation industry. I'm going to ask for a friendly amendment to cut all the aviation parts of it out of it. But what is left of that bill pertains to eviction service. And I'm joined here by Mike Williams, who has practiced landlord-tenant law in Atlanta for 30 years. When I was first practicing in Fulton County Magistrate, there was a window and it had a sign, this isn't Burger King, we don't do it your way, we do it Judge Levinson's way, and Judge Levinson's still around. But then there was a big cubby hole with Mike's Law Firm's evictions, and then they had like an accordion file for everybody else. So he definitely knows landlord-tenant law. He identified the Mancuso versus Cadle's case decided in January of 2024, and what that case did is it said, based on the plain language of 44-751, there is no provision for service of evictions by a private process server like there is under 911-4. And that was news to everybody who's practicing that field. The common practice was using private process servers. So what this bill does, it lines up 44-751 to 911-4. It just conforms to decades of practice, if not, longer than that, in response to the Mancuso decision. I heard about that case in court in Henry County and definitely made provisions temporarily, but this bill will get us back to the standard practice. You either have to have a standing order appointing the private process server, or you've got to go ask the judge. So there's plenty of due process there about that service. So that is House Bill 270. It'll help us with landlord-tenant law and codify the longstanding practice. So on the friendly amendments requesting lines 1 through 3, strike that part out about aviation law. On Section 1, strike out the and airplane evictions language. Section 2, strike that in its entirety. Section 3 is our eviction service portion. And then Mr. Williams brought up a good idea. Let's add some language making it effective upon the governor's signature or coming into effect without the governor's signature, since this is such a cleanup bill and everybody knows this area of the law pretty well. So those are the requests in the presentation. Mr. Williams is here to answer questions, as am I, and would request your approval of this bill. And I would like to thank the aviation folks for continuing to talk about those important legal issues outside of this bill.
Any questions by the committee? I don't see any. Oh, here we got one over here.
Thank you, Mr. Chairman. Hey, just you and I have talked about this some, so I'm just making sure Georgia Airport Association is now happy with this amendment. Is that
correct? The Section 3 of the Section 3 of the bill, eviction service, had no impact on the airports.
okay?
Section 2 did, and so
And that's gone.
they understand that we were proceeding just with the eviction service, not the aviation.
Okay, so all the worries about an FAA complaint holding this up indefinitely are gone now.
They are in this bill. They're continuing to talk about those issues, but not in pending legislation before the committee this morning.
Okay, thank you. Thank you, Mr. Chairman.
All right. I don't see any other questions. Now, I think we have a couple of people that want to come speak on the bill.
He's right there.
Oh, he's there. Okay, got it. Well, Vernon Lee, though. Vernon, you want to speak?
Mr. Chairman, the committee, the amendment that Representative Reeves just did, striking that section, the Zero Aviation Airport Association, which is 95 zero aviation airports in the state, or good with the bill moving like that.
Okay.
So other than that, I don't have any other comments.
All right, thank you. All right, what's the will of the committee? Got a motion and a second. Any further discussion?
We need the amendment.
Oh, that's right, we do have the amendment. Glad I asked. How do y'all want to handle that? Do you want to do it as stated by the witness? Does everybody understand it? Okay, we can do it that way. And I would add that we renumber the sections.
Absolutely. And I'll work with Ms. Carter to get that cleaned up for Rules Committee.
Okay, all right. Any question about the amendment? Okay, all those in favor say aye. Aye. Any opposed? All right, you have those amendments.
Thank you.
Now for the bill, any further discussion on the bill as amended? And we are dealing with LC 481433, is that correct?
I believe so.
Okay, all right. All right,
Actually, I had 481497S, but I think those changes were in all the versions. I think those sections and the setup were the same.
all right, what I have here is the 481433.
There were some changes within the airport section, but that's all coming out.
Okay, so we are passing 481433
Yes.
with the amendment, right? Okay, all right. All those in favor say aye. Aye. Any opposed? All right, there, you got your bill.
Thank you.
All right. You had House Bill 132.
Yes, Mr. Chairman and members of the committee, House Bill 132 is the Senior Municipal Court Judge Bill. As originally filed, LC 473211, it only pertained to municipal senior court judges. We had discussion of the substitute about sovereign immunity the other day, and I appreciate everybody putting time into that. What we've done following that committee is I'm asking for just the municipal senior judge bill as originally filed without any sovereign immunity provisions. There is a bill that Chairman Leverett asked me to work on for a variety of reasons, House Bill 531, that pertains to municipal sovereign immunity. So I'm going to move everything that's under discussion about municipal sovereign immunity into that bill, which will be heard at a later date, and give time to continue to talk to cities, to trial lawyers, to all affected parties about that issue, and to honor the work of the senior municipal court judges. They're here at the Capitol today. I hope you're able to connect with any of your community. We have Judges Will and Barrett here in the room. I know Judge Margaret Washburn from Gwinnett is here as well. There was some follow-up to Chairman Gunner based on some questions he had about how they're going to set up the senior judge list so that various cities can call on these judges and be able to fill staffing needs. But this bill will help our municipal judicial landscape with the senior judges, and respectfully request approval of the bill as originally filed without any sovereign immunity in it.
All right, Chairman Smith.
So is it my understanding I'm going to run into the same problem I have with certain superior courts and state courts, that I think I know I'm going in front of a certain judge and I'm going to have another judge instead under this bill?
It is not as formal as the Superior Court senior judge and state court senior judge system. This is more one where they're going to be able to call on them when needed. So it's not quite as formal of an appointment as you have in state court. And for instance, each city will have to engage the senior municipal court judge, whereas with the senior state and superior judges, they're on call for different circuits and things like that. So
Okay.
I think you'll have a lot more notice of who's here in your calendar in municipal court.
Outstanding, thank you.
All right, any other questions? We don't have anybody speaking on this. All right, what's the pleasure of the committee? All right, got motion and a second. All those in favor say aye. Any opposed? Okay, thank you. Got that. All right. Representative Yurda. Representative Yurda, come on up. House Bill 304. I see I signed on this bill. It must be a good one.
It's a great bill. That's right. Thank you, Mr. Chairman, committee members. This is a bill some of you or most of you probably heard before. We've actually it's passed here at least, I believe, 3 times, and actually came up, it was passed Judiciary in the Senate, but didn't quite make it on the floor last year, and we're back to try it again. It's House Bill 304, LC 481432, and this bill simply creates a Georgia Municipal Court Clerks Council, or statutorily recognizes that in the state of Georgia. There are 389 active municipal courts in Georgia, and it's the largest class of courts in Georgia, from Atlanta that holds court multiple times a day to small cities that may do it every other month. Despite the diversity in these courts, they all have to follow the same rules. And the reason for this bill is to help to assist with standardizing the municipal courts and further bring professionalism and administration of the courts. This will help them to work together, to know, to have everybody on the same page, to professionally run these courts and develop mentor programs. And this allows the courts to better serve the public, and more of the public goes through municipal courts than any other court. And the municipal court judges support this legislation. Just ask you to pass it one more time for them.
All right, any questions? Seeing none, and I don't think we have anybody speaking on the bill. Motion to pass? Motion and a second. All those in favor say aye. All those opposed, same sign. The bill passes.
Thank y'all.
Thank you. All right. Moving right along. Let's see.
Representative Martinez, Representative Jones.
Okay. Representative Martinez, you want to come up? I'm just going down the list right now.
Chairman, that's Lou Ross.
What now, Lou Rawls?
That's right.
You've now made a name for yourself.
That's right. That's right. Thank you so much, Chairman. I bring you Bill HB 325, LC 46, 1038 or 58 outside.
Yeah, you need those glasses there.
I need those glasses. That's right. LC 46, 1038. Basically, and next to me I have Joe Ferreira. You all know Joe, Deputy Adjutant General, and Lieutenant Colonel Piesta.
Edward Piasta.
Piasta. And also in the back, I have with the GBI, GCIC Director, Rhonda Westbrook. Thank you so much. And they're all in support of the bill.
All right.
All right. Basically, Chairman and Committee, this bill allows a military judge to enter a military protective order against a guardsman who is alleged perpetrator of a crime who is now stalking the victim. Unlike the protective order that is currently available, this order would apply to guardsmen who is alleged perpetrator 24 hours a day, 7 days a week, regardless of what duty status he or she is in. This gives the guardsman who is alleged victim the same protections they would have if he or she were on active duty installation. So the same protections. This bill also gives the alleged perpetrator due process by giving him or her the opportunity to present or defense prior to the issuance of a protective order that could negatively affect them. And that's basically what the bill does. And I have Mr. Joe and the Lieutenant Colonel to to answer any questions if the committee may have, Chairman.
The content of the protective order is similar to a civil one, is that right? Like take away guns, that kind of thing?
Yes, sir. It's very similar. There's a form that will be developed. That will be a checklist for the commander to fill out, and then for the judge the military judge. It'll be a military judge that is part of the Georgia National Guard, would be the entering authority. But yes, it is a very broad protective order,
Okay.
including weapons.
Okay, all right, great. Thank you. Who's 18? Chairman
Mr.
Leverett.
Chairman. Thank you, Mr. Chairman. Thank you, Representative Rawls, for bringing the bill. But all seriousness, all joking aside, and very seriously, I think this is a great bill. I just want to make sure I understand conceptually, is Title 38, or does a particular chapter in Title 38, is that kind of our state code of military justice?
Yes,
Effectively?
yes, sir.
Okay.
It is.
So we're basically taking the existing stalking order provisions from the civilian part of the code and putting something similar to that sort of legal infrastructure in the state code of military justice, so a military judge can issue one of these orders with respect to someone in the military.
Yes, sir. It's very similar to that.
Okay.
And if I could just add, out of the 14,000 guardsmen that we have in the state of Georgia, about 80% of them are part-time guardsmen, which is why we need this order to be passed so we can protect the potential victim 24/7, as Representative Martinez mentioned.
And I think the representative may have covered this, but it didn't land with me. Would this procedure apply only when you had a military petitioner and a respondent who was a member of the military?
Yes, sir.
Okay, all right.
So both parties have to be?
Correct.
I got you.
Correct. Otherwise, it would be a civil
You
court
just
matter.
be in a regular,
Right.
you go to Superior Court. And
Okay.
But this is to deal with military discipline within our organization.
Gotcha.
Yeah.
All right.
And is one other question, Mr.
Yes, sir.
Chairman, is what are the mechanisms in a military court for enforcing an order issued by, and I keep calling it a military judge, I know there's a different word for it, forgive me. Is the mechanism the same as contempt? Can the judge imprison for a failure to comply with an order?
So, Ed, do you mind getting into the details on that?
Swing that around over there. There you go.
That is correct, sir. There's actually contempt provisions in the bill that allow that. You can be imprisoned up to like 30 days and fined. Additionally, from a military standpoint, a military protective order is a lawful order to a soldier or service member that can be ultimately can be prosecuted for that under the GCMJ.
Okay.
Under the GCMJ, not civilian wise.
Yes.
So it's definitely enforceable because it is an order not to stalk.
Okay. All right. Thank you. Thank you, Mr.
That
Chairman.
brings up another question then. Does the local sheriff have to comply with the order if there's a violation of it and hold the individual?
It is now. We, from a guard perspective, I don't think we can afford, but it will be uploaded into GCIC, and that's why Director Westbrook is here. So they would be required to, it's a violation of Georgia law.
They could act on it if they get called to a house where the alleged victim is,
Okay.
and the alleged perpetrator is there. They'll run that through GCIC,
Okay.
and they'll find a copy of the order, and they can apprehend him and then turn him over to us.
So a local judge then would have to interpret the order and issue a warrant. Is that
Well,
how-
I'm just saying, if he was there on the spot, if the sheriff responded to a call and the perpetrator was there and they ran the order and found that he was in violation of the order, they could hold him and then they would turn him over to us.
Okay.
I
I was just trying to clarify if they had to go to a magistrate to get a warrant, but they can operate just like they do on any other protective order. Is that correct? Okay, thank you. All right, Representative Hong.
Thank you, Chairman. Would this in any way prevent two military personnel involved in this for them to go to just a superior court?
No.
So meaning just jurisdiction-wise, it's not, they can choose to go to superior court, they can choose to petition within military. Court.
Yes,
correct?
yes, they could still go to civilian. So the situation that this would help us with is, say there's an alleged sexual assault of a military member by a military member, and because, well, it could affect unit cohesion, unit discipline, all that sort of thing. So it's kind of a commander issue, which is how it's dealt with right now, but there's all these other issues that we'd like to resolve by having a military judge handle these orders. But if it was more of a civilian thing, they could certainly go to a superior court and get a protective order.
So they have the option.
Yes, sir.
So how do y'all get notice of it then?
So if it's a civilian matter, it's a civilian matter.
Right.
We would get notice of it if a alleged victim came to the commander and said, my fellow soldier here assaulted me. That's how we would get involved in that. And go from there. And then if he or she asked for a protective order, or if the commander thought that was the right thing to do, then we would petition and have the Georgia National Guard military judge hear the case and issue the order.
Okay, all right. Go ahead.
I think, Judge, wait, so if they go to civilian court, you guys don't have any, there's no obligation or any type of notice that you would get that's outside of what you guys deal with. So there may be some kind of a protective order that's out between two military personnel issued by Superior Court, but unless one of them brings that up to you, you would not have notice of that. Is that correct?
That's correct.
Okay.
That's correct. Now, I would imagine if an alleged victim had gotten a civilian order and they were and she and the alleged perpetrator were in the same unit, she would bring that order to the commander because they're supposed to be separated, and we would help, enforce that and not have them drilling together or in the same unit. We would accommodate that. But that's how we would find out about a civilian order, is by one of the parties bringing that to our attention.
And do you find out about that on a regular basis because the alleged or the victim notifies?
So fortunately, it's not a very common thing for us, right? But there have been a few times where we have become aware of a civilian protective order, and we'll relocate one of the soldiers to a different unit while it's all being sorted out in the civilian court, so they're not having to confront each other in the workplace.
And you don't believe that it's necessary for us to do something that may say that you would get notice, you should get notice?
I mean, that's on the civilian side, so we weren't really contemplating that. So I can't really think of a situation where one of the parties wouldn't bring it to our attention. And like I said, it has a couple of times, and we've dealt with it. So I don't know if you want to go into the civilian protective order system and amend that or not, but this one would allow us to deal with our internal situations that we're aware of.
Okay, all right. Got Representative Holcomb. Is that you? Or, Estration. Leader Estration.
Thank you, Mr. Chairman. Thank you, Representative Martinez and witnesses. Just looking this over, it looks like this would just apply to protective orders concerning stalking. Is that right?
Yes.
Okay. And so the sexual assault example that was just used, that's not in the kind of family violence context that we have existing protective orders. It would just be if there was stalking, I guess, as part of that crime as well.
Correct. It
Okay.
resulted in that.
Yeah, I just wanted to clarify that. All right, thank you.
Thank you. And I'm just checking, is there any gaps in the jurisdictional part with the federal government land? If they're on base and there's an incident there, y'all take care of it with this order here, is that right? Or
Yes. So some of our armories are on federal bases. Some of them are in your local communities. But this is about the persons and jurisdiction over the persons as members of the Georgia National Guard.
Okay.
So we have jurisdiction over them as uniform members of our organization.
Right.
And so where this happens, as long as it's within the state, I think it would have to be in the state. But where it happens is not as important as who is involved.
It's just really what court they want to select, I guess. Is that right?
Well, if most of our people are traditional guardsmen, which are part-timers, so if they're having, trouble in their off-duty time from us, where it's the other 28 days of the month as opposed to the 2-day drill weekend, they may very well take care of that because it has really nothing to do with the guard.
Mm-hmm.
And they may take care of that in the local community, in a local court.
Okay. All right. Any further questions?
Chairman, I got, if she wants to come up and add, Director Westbrook, would you like to add anything? From the GBI perspective.
Yeah.
I don't have anything to add unless someone has questions regarding our present protection order registering, but I don't have anything else to add at this time.
Okay. Thank you. All right. I don't see any other questions. What's the will of the committee? I got a motion and a second. Any further discussion? All right. All those in favor say aye. Aye. Those opposed, like sign. Okay. Bill passed.
Thank you.
Thank you. Thank you for your time.
Yeah, might as well. You ready?
Yes, sir.
Motion to
Okay. All right, let me get this right here. Mr. Chairman.
All right. You're up.
Well, thank you, Mr. Chairman, and members of the committee. Thank y'all for indulging me on House Bill 379 today. On your desk is a letter from my Superior Court Judge, Dean Bucci, who's the Chief Judge of the Paulding Judicial Circuit. So y'all can review that while I present the bill. The proposed legislation aims to address, and I'm sorry, this is LC 481554. The proposed legislation aims to address an unattended application of OCGA 15.
What did you say,
LC 481454.
You said 15.
Oh, it is. I'm sorry. Yep, my apologies. The unintended application of OCGA 15-19-14, which authorizes attorney liens, while originally intended to ensure attorneys receive, and is it okay if I present from here, Mr. Chairman? I hope that's okay.
Go ahead.
Receive fair compensation for their services, the statute has been leveraged in certain divorce cases in a manner that undermines the judicial discretion in awarding attorney fees and unfairly impacts the division of marital property. OCGA 15-19-14 allows attorneys to file liens to secure payment for services rendered. This provision is fair and necessary when used properly, such as when a client attempts to settle a case after dismissing an attorney without compensating them. However, in some family law cases, attorneys have used liens to encumber marital property, effectively bypassing OCGA 19-6-2, which requires judges to consider financial circumstances before awarding attorneys' fees in a divorce. Here's a great example. In a divorce case where the wife is awarded the marital home, but the husband's attorney has placed a $50,000 lien on the property, the wife effectively loses all the equity in the home, circumventing the judge's authority, and forces one party to bear the other's legal costs unfairly. So to prevent this misuse while preserving the appropriate function of attorney's liens, the legislation proposes two key amendments. One, amending OCGA 19-1-1B. Courts currently issue standing orders that prohibit parties and their agents from encumbering marital property during a divorce. However, once an attorney withdraws from a case, they are no longer considered an agent and can still file a lien. This bill would add language clarifying that both current and former attorneys are bound by these orders. And you'll see that there in the bill. And number two, it'll amend OCGA 15-19-14 to explicitly prohibit attorneys from encumbering marital property or property awarded to an adverse party. The bill would add the language that you see under subsection G. So we feel like this would ensure that judges and not attorneys are determining the fair allocation of attorneys' fees in divorce cases. It prevents one party from unilaterally shifting legal costs onto the other by weaponizing attorneys' liens, and we believe that this closes a loophole in Georgia's attorney lien statute and reinforces the judiciary's role in ensuring those fair outcomes in a divorce proceeding. With that, Mr. Chairman, I will answer questions to the best of my ability. As you know, and I'll give $1, I'm not an attorney, but I do know we have some very well qualified folks here on this committee to consider this. Thank you, Mr. Chairman.
I guess I need to get one of those jars, huh, to collect the $1. All right. Does anybody have a question to the author? Leverett, Chairman Leverett.
Sorry, Mr. Chairman, just a quick question. So what we're trying to do is clarify that 1519-14, which is the statute that gives attorneys liens on property of their clients for the work they do, similarly applies with respect to a lien you would have against real estate recovered. I think that's the language the statute uses. That means you would have a lien on something your client recovers to pay the fee that your client owes you, but you don't get a lien on something awarded to an adverse party to pay those fees.
That's correct. Yes, sir. That's right.
And then the section 2 amends that section about orders, and I think standing, that's the code section that basically authorizes courts to issue standing orders that automatically apply in a domestic case. And I didn't quite understand how these changes sort of dovetail with this first section. I guess, is it just making it clear that a standing order also would bind attorneys and former attorneys to the extent it has provisions addressing those issues?
That's correct. And
Okay.
to add a little color there, I think, when I talked to Judge Bucci, Judge Bucci, he had said that there are some folks that are now kind of using this to encumber property. So they're kind of bad actors in that way, where they get in, they're encumbering a party, knowing that they're going to become an agent eventually, and then they're basically encumbering the adverse party's equity in the home.
I guess the only question I have, and maybe some of the folks who do domestic work here could weigh in, but my understanding is on occasion an attorney might be awarded might get an award that an adverse party pay fees to that attorney. And in that case, it would seem to me like they ought to be entitled to assert a lien in that case, although admittedly I'm Rule 33 out of voting on that one. But that would just be a concern of statutory construction that I just submit to the folks who do more of that work on the committee.
Sure. And I think you probably have a point there. I will say that Judge Bucci regrets not being able to make it today. He had missed the time he's presiding today, so I'm sure he would have some very astute comment to reply to you. I wish I could have.
Thank you, Mr. Chairman.
Thank you.
He's the judge. He can set his calendar any way he wants to. All right, Representative Oliver. I hope I've got you. 16, is that right?
No, I'm 16, but you can use it.
I'm not sure if this is working. I'm not.
Yes.
It doesn't light when I push the button.
I got 14 and 16 lit up. So
I'm used to having the family law section guide us on these matters. Do we know if anybody from the family law section has seen this or opined or here to talk about it? Any witnesses want to talk about this?
Nobody signed up.
I use attorney fee liens on estates. I've never used one on domestic cases. But I'm a little confused because clearly I sign a retainer agreement with my client, and the court is not involved in what I am owed from my client. And my client and the husband, let's just use as a practical suggestion, own assets together, owns properties together. And in a wide variety of ways that we can all list if we want to take an hour and list all the ways they own properties together. I'm trying to figure out what that means in terms of this bill. It means that I can't put a lien on anything that is jointly owned. Is that correct?
That's what I'm reading.
And the lien could come before the case is resolved ultimately. I mean, there could be temporary orders. I'm trying to figure out all the circumstances where the joint ownership would prohibit, this shall not allow, does this prohibit the judge from saying, I'm awarding you in this temporary hearing $25,000, and the judge says, but you can't put a lien on anything? Is this, I'm confused a little bit.
Because getting the order and collecting are two different things.
Right.
So, yeah.
Maybe I can cover it in. I think in the letter that was submitted from Judge Bucci, and I'm, again, only reading this, there is. Yeah.
It's this.
So he says the primary statute authorizing attorney's fees and awards in divorce cases is 19-6-2, which requires judges to consider the parties' financial circumstances before awarding fees. Considering financial circumstances in the hypothetical above, no judge will require the wife to pay the husband's attorney's fees. However, by filing a lien, the husband's attorney can circumvent OCGA 19-6-2 and collect his fees without any consideration of financial circumstance. I think that is kind of the crux of maybe his issue there, but I leave it to the committee.
I'm just trying to figure out how this would apply on temporary orders. You know, divorces can go on for years, and it's anticipated that fees could be awarded at any time. Assets could be distributed at any time, or not distributed.
Okay.
Thank you, Mr. Chairman. I appreciate the thoughtfulness of Judge Bucci. I think he sees a problem here. I think there could be some gamesmanship being played on this regard, but I worry by creating a problem here, we may create a bigger one there. Maybe a question to the chairman who sat in that role as a judge. Would most judges not take that filed lien into consideration when they're making the distribution of property? I mean,
well, most of the time, as I remember it, I would order, if I grant it, I would make the order to granting it and let them figure out how they're going to collect it. So, not unless it was brought specifically to me to ask for a lien on that. I never had that issue.
Okay, so you would award it. Okay.
Perhaps
Let me get you on. You're on 14.
15.
We're 15.
This is 14.
That's on there.
I got them all lit up. Don't worry about it.
Forgive me for interrupting. Maybe shall not authorize an attorney. That's what bothers me. And maybe if that language said unless ordered by the court. I mean, I think the injury is the unknown to the court part. And if you're negotiating a partial settlement of a business prior to the ultimate divorce, so the business can run, I'm thinking about all the possibilities here that shall not seems so strong.
Yeah. Glad to have all the wisdom and experience here. Okay, I need to get over here because this one's been going. Who's got number 1? Leader Restoration.
Thank you, Mr. Chairman. I hear the chairman's and what Representative Oliver was talking about. I don't know a whole lot about the attorney lien statute and current procedure on that, other than to say my concern would be sometimes the property's titled in one party's name before the final. You potentially need to file one of these in advance. And then also, if my concern along the lines of Representative Kelly's comments was that this hypothetical the judge has outlined for us here I think is helpful, but my almost concern will be the wife who does not have income. There'd be a chilling on her having counsel because there'd be uncertainty as to whether or not that attorney would be able to collect ultimately in the case if that house, say, were to be awarded to the husband in this example. And then suddenly the lawyer representing the wife not being paid but knowing that there's an asset to ultimately collect on may not have the ability based upon what a judge or jury does at final trial, which is just very unpredictable often. So anyway, those are just my thoughts, and I'm happy to get with the sponsor at appropriate time. I appreciate the judge's clear outline here and the sponsor bringing this discussion.
Yeah, I'm thinking we need to make this hearing only today so that some additional work can be done.
Okay, I'll wait for you.
Okay. And Chairman Leverett, you have?
I was just going to suggest, would not the court, if a lien had been placed prior to the conclusion of the case and the court, as it was exercising its equitable powers to fashion a decree for equitable division, could not the court, I suppose with some notice to the attorney, provide, well, I'm awarding this property to the spouse, the lien has been filed by the husband's attorney, so I'm going to transfer that lien to property that I'm awarding to the husband.
Mm-hmm.
Now, I suppose there's some due process issue if the court does that with no notice to that attorney,
Yeah.
or with giving that attorney an opportunity to be heard, but it would seem to me that would be a way
That's
to
a
handle it.
realistic scenario.
If the
yes.
court's aware of it, which is, I think, the concern here, that the court may not be sometimes aware of it.
Hang on. I got to light them all up here. Go ahead.
Historically, I have heard of cases, this would be probably unethical in any case, but of a lawyer just negotiating with the client, I'm taking a lien on your house right now and that's your fee.
Mm-hmm.
And that would be outside, I don't know whether that's ethical or not, but there's been some real estate acquisition through that mechanisms from some lawyers who've done a lot of large volume divorces over time.
Yeah. Yeah.
How does this reflect to that kind of fee arrangement?
This may be an area that could use some cleanup in it. So, yeah, I agree. All right, who's got number 5 over here?
Thank you, Mr. Chairman. I wanted to understand Section 2 a little bit better. What kind of, I was trying to look up the code section and I'm just not fast enough, I guess. What are the injunctions and restraining orders that we would anticipate needing to apply to lawyers? And that's to the author or anybody who does. I don't practice domestic. Yeah.
No.
Depth of knowledge. I leave to the committee.
All right. Chairman Leverett.
At the risk, Mr. Chairman, of becoming the Eddie Haskell of this committee, I actually was able to pull that up because I've been having trouble pulling up the code too the last few days. And it's really just the standing order authorization. Upon the filing of any domestic relations action, the court may issue a standing order in such action which, 1, and that's the one we're amending here, upon notice binds the parties in such action, their agents, servants, and employees, and all other persons acting in concert with such parties. What I think is happening in Section 2 is we are statutorily authorizing courts to provide in their standing orders for provisions that would bind not only parties, but attorneys and former attorneys, so that the court could try to address some of these issues in the standing order with respect to the filing of liens. And when it could be done, and when it, the fact that maybe the liens could be transferred to other property or something like that.
And my concern, and perhaps the folks that work on this after this hearing only, is I just am not as familiar with the standing orders, but I don't think it would be, I think it would not be, we wouldn't be allowed to do it anyway because it would be unconstitutional, but to the extent any of those standing orders have like non-disparagement clauses or things you just simply can't bind attorneys like that. And I think that would be well beyond the required restraint that probably some of these standing orders are attempting to like protect minor children and things like that. So I just think we need to be a little bit careful. And it may not be an issue. Since it's hearing only, I wanted to raise it.
Thank you. To the author, I would suggest that you and the judge get with the domestic section of the bar, and I think they could help y'all straighten this out.
Yeah, I will pass this information along to the judge and let him, of course, watch the proceeding here today to kind of determine, how he wants to move forward with the bill and get maybe some input and answer these questions. I hope the next time he's able to make it. It was an unfortunate scheduling mishap, so we'll try to make sure he's here to answer these questions in the future.
Okay.
Thank y'all for hearing the bill today.
Thank you. All right. This was 379. All right. Oh, Representative Reese. Let's see. All right. Let's see which mic you want to use.
Yes, sir.
You have a
Mr. Chairman.
substitute, is that right?
Say that again.
You have a substitute to House
Yes,
Bill
sir.
427?
Yes, sir. We are operating off of House Bill 427 LC 481533S.
Okay. All right, tell us about the bill.
Thank you, Mr. Chairman, and thank you for your patience. I know we were scheduled for yesterday, but I'm working with an amazing group of people that we were able to work some things out yesterday, and so this time that you gave us was extremely helpful. I do want to say thank you to Mr. Greg Allen here with the Clerks of Courts, Ms. Dana Chastain, who couldn't be here today, Lori, and some other individuals that we've worked very closely on this bill. Last year, this body, as well as the General Assembly, recognized that we are having a problem in our state with deed theft. And so this bill kind of goes to that to provide some additional protections for Georgians. This bill looks more at the proactive stage of it. And what I mean by that is most of the provisions that we have right now are things that people can do afterwards, the penalties, the fines, the things of that nature. What we're running into, and Dean Green is the co-sponsor of this bill, in parts of rural Georgia, we're seeing very, very poor people that are having their deeds taken from them, and they don't have the resources to pursue, to get it back. So in a nutshell, what this bill does is it says if you are not the homeowner, or you are not one of the individuals carved out in the exemption in the bill, which includes like real estate attorneys, probate attorneys, bankers, there's some other lists, there's an entire list in there, or you're not a family member with a power of attorney, what happens is when you file this deed, the clerk will put a note on there saying that there's a hold on the deed for 45 days. And within that period, the clerk's office will send out notification to the address on file or the email on file, because we do have the electronic option, to just let them know that, hey, someone is here filing for this deed, in case you're not aware, because, we don't want anybody taking your property. And what led me to this, Mr. Chairman, after speaking with Dean Green and so many other brilliant people, is that, I think about the towing industry, where if a vehicle is towed, an individual receives 2 certified letters before that tow company can begin with the auction process to cover their fees. And I just felt that there should be some type of notice given to the people of Georgia that someone's trying to take their deed and they're not aware of it. It's happening to our seniors. It's happening to some of our servicemen and women that are gone for a long time. Their property's paid for. They come back and the deed is in somebody else's name. Again, I want to thank my partners, the clerks, the real estate community, the credit union community, banking community. We all work together to make this bill here work for everyone. There is an electronic filing component of this bill as well. We have spent a lot of money as a state updating our Superior Court clerk's offices so that they can move forward with electronic filing. A very large volume. Over 95% of the work now that comes to Superior Court comes to electronic filing. So we're moving toward the aspect of having all work done electronic filing. They have placed workstations in every lobby of every Superior Court clerk. If someone comes in with paper, they can give that to the people there in the office. They will help them scan it in. They're ready to be friendly with that. And that's also going to help from a theft perspective, because we're getting an account of the electronic transaction. In the office, the system will take a picture of the individual. If they're doing it online, we're tracking IP addresses as well as the sign-in code for someone who may be using the court's system. So with that, Mr. Chairman, I present this bill and do ask for favorable consideration of this committee.
The clerk's authority is okay with this bill?
Yes, sir. Mr. Allen?
Yes, Mr. Chairman.
Okay. And I have some questions about that.
Yes, sir.
If they bring the deed in and they're to hold it for 45 days, how's it held?
Well, operationally, they're going to go through the process they normally would. They're going to put a note on the file. So if a title attorney comes through later on looking at that same file, they will see a note saying that this particular deed right now is subject to this code section, which is really House Bill 427, saying that there's the 45-day consideration because we are trying to make sure we get clarity from it. So it's not going to sit on anybody's desk. It's going to go through the process. The hold is, and we updated that language just this morning, the hold is actually going to be notice that is put on the file saying that this file is under that consideration of the 45-day period.
And how is that removed?
It's removed once the individual actually comes in, or if they don't come in, then once the end of the 45-day period, it's taken off and the transaction is clear.
Yeah, but how does that, what's the mechanism of that?
The document that they place on, they'll pull off, from my understanding. Ms. Chastain said they can pull the document off. The clerk's office can.
So it doesn't stay in the record marked a particular way. Is that right? You might as well come on up here. I got questions.
Come on, Mr. Alley.
The way, thank you, Mr. Chairman.
Yes, sir.
The way we envision it is, it goes on the record with the note on there, and after 45 days, it's either, it becomes, there's no issue with it, or the person has protested within that 45-day period that there's an issue.
And if they have, what happens to the deed that's on record now?
That'd be for the courts to decide.
Yeah, if the person has an issue, then they will have to seek civil action. The individual who's asking for the title transfer is going adverse to the person who's actually on the deed, so they would have to take civil action if they want that deed transfer. Because we have the owner here, the current person telling us this is not an authorized authorization. At this point, you're saying if we get to that point.
Basically, I guess, wouldn't this be a forged document? And you wanted to make them go through a court hearing to unfile the document? That's kind of where I'm coming from.
The question again, I'm sorry, you lost me there.
It's a forged document if it turns out, they go through all the process.
Right.
Because this is somebody else doing this.
So I seriously doubt if they'll try to enforce it if they're told that this was challenged.
It's sitting on the record now in their chain of title, so I'm kind of wondering, why do we want to mess up their chain of title with the document sitting there that's really no good and it was all a forgery? I'm just trying to figure out how do you get rid of it?
If it's the chairman's wish, I have no problem with us getting rid of it. If you guys can think of a way operationally to actually totally remove it, I see what you're saying, and I wouldn't have an issue with that. Actually, I think it would make it cleaner if we did that. It makes sense to do that. So how can we do that operationally?
I'm thinking we always are hesitant to change the face of any document filed with us is where we're stuck.
And that's why I asked the question, because I know I've done title work before.
We'd have to, you've got the affidavit process.
Right.
I'm thinking an affidavit filed on top of that deed showing that it's clear. And that's me thinking off the top of my head right now.
But that's not in the bill here, right? Or is that in law now? Can you do it that way?
Is it line
No.
35 where we entered that notarized?
Laura, you want to come on up? Come on up, Laura. Come on.
Well, I know there's an expert in the room here.
Right,
I was going
right.
to call him Chairman Leverett if he has anything to say about it.
Well, I was just going to, Mr. Chairman, currently I think that is, if someone files a forged document, you've got to get a court order to have it, canceled or voided. You'd have to file a quiet title, which is expensive, but that's kind of, I think, in order to protect the record from people, ripping pages out of the deed book. That's kind of what I think the procedure we have, and there may be some exceptions. I know we had when you had those sovereign courts going around filing a lot of liens. I think there is a statutory procedure for getting that removed, or you can file something to counter it. But generally, once it's on the record, it's on the record forever.
So if it's there, and it gets cleaned up with a court order somewhere down the road, and that gets filed, is there a reference made on the forgery over to? Because I know you do it on.
Yes, we would cross-reference
that
court order. Yes, sir.
Okay, so that would help clean up the title.
Yeah, that would show the clear chain. Yes.
All right, but they got to go through all that process to get it done. All right, that's all my question. Anybody over here? All right, who's 13 or 14? 14. You're 14. All right.
Thank you for the sponsor for bringing the bill. I do know of people that have been victims of this type of situation, and so I do think it's important that we come up with an answer. But my concern is that, if there really were bad intentions here, someone could deliberately do this to someone in terms of other litigation, in terms of a divorce, in terms of a business separating, in terms of other things. This would just put a wrench in all of that and delay it at least 45 days as kind of a delaying tactic. I'm also concerned about just the cloud on the title, just because I know that, you cannot get title insurance on a piece of property if there's a lien outstanding or some type of recording like this. It would be impossible to transfer the interest in the property with that cloud on the title. So I'm puzzled. This is a tough one.
Yes, sir. And I appreciate your question. And as far as the first question there, it was part of the reason why we wanted to make sure that the exemption list was exhaustive, because we do understand we're talking about a very small volume of deeds here, but it's extremely impactful to those families that have this situation happen to them. And I appreciate Mr. Allen and Ms. Chastain, because we really grinded this, like, how do we make this work, Mr. Chairman? You know, making sure that we're not holding up the title process, you know, attorneys trying to do real estate transactions, banks, and things of that nature. So in the first scenario that you announced there, that you talked about briefly, if it is someone doing actual legal work, this doesn't bother them at all. That they're exempt from this. And that's what we wanted to make sure, that 98% of the work that we know comes through, that's not problematic, where there's appropriate legal representation, that they're not held up by this process.
All right. Well, then that brings me back to the 45-day period. What good does it do? I mean, you're filing the fraudulent deed on the record for a 45-day period of notification. Basically, you're giving notice to somebody that brought in this deed that wasn't part of the title. So I don't see the need of the 45 days, because they still got to go to court and litigate this out.
The original bill had us holding it, but at the concern of our partners here in trying to compromise on it, they didn't want deeds just piling up somewhere, sitting there, you know, never hitting the record. They wanted the process to continue, so the compromise was to allow the process to continue, but to put the note on the file. Now, you know, you have a legitimate question, Mr. Chairman, and I would like to see us work through this better. Again, the intent is to help those that are having their homes stolen from them. You know, how do we do that? Do we consider Mr. Chairman's recommendation that we never file it out? Because it is a lot easier if it's never filed. But right. Then you do have deeds somewhere sitting there, you know, that someone has to manage and make sure after that period that it goes through. Laura, you...
Gosh, I'm a little out of my skis here,
okay.
If I'm being honest. I think what on the 45-day notice, if you look at line 35, I know the clerks were trying to get and put in there that the notice would have to be in writing by a notarized affidavit sent by mail, and that is or affirmed in person, and that would be what was attached to the deed, so that we would know why it is. But again, to clear it up, I don't know how you fix it.
And let's talk about what happens in the 45 days, because it's not just an arbitrary day. The bill also gives the clerk's office 15 days to get the notice out. That's a part of that 45-day period.
Right.
You know, so we're trying to give them enough enough time to deal with their normal volume and get that out. And then once the individual receives it, giving them an opportunity to reply. So we're looking at like a 30-day period or 25 to 30-day period, hopefully, that the individual will have that notice and have an opportunity to respond. Again, Mr. Chairman, I see your concern here. If we can prevent it from hitting the title, the record altogether, I wouldn't be opposed to that either. I just know that my partners here were concerned about a deed just sitting around and nobody doing anything with it.
I get that, but I think that the idea of the bill is to have that in a box or something. That, of course, the rural clerks would do it that way.
Yes,
just
sir.
sit in a box somewhere.
Yes,
but in the big counties, I can see where that's a real problem. So, all right, Representative Kelly.
Mr. Chairman, thank you. I understand the problem. I don't understand the solution necessarily. And in terms of, I understand where you're going with it, but first I want to make sure that there's no intention that, what if someone gets it, grandmother, someone tries to file a fraudulent deed, the grandmother doesn't respond in the 45 days. We haven't created a mechanism now where they don't still have the opportunity to go seek redress in Superior Court, are we? Because that's what I'm worried about. So say somebody files a fraudulent deed, the 45-day period passes, and I've taken no action.
You
still have
the recourse? Yes, we haven't taken away your legal recourse. This basically gives notice. That's the purpose here. Giving notice to, because I have a 91-year-old grandmother, and I thought about her doing this process. This is to give notice during the process so that they can hopefully, and you're absolutely right, to seek that action, though, requires funds. And the people we're fighting for, many of them in rural Georgia, they don't have the money, Representative Kelly.
I know,
to
I
put
live
that on
there.
the back
Trust
end.
me.
You know, and so this is to give them an opportunity on the front end before they have to, but we're not taking away their ability to do exactly what you just said.
That's what I wanted to make
sir.
clear.
Yes,
I want to make clear that. And then second, I'm trying to figure out, Mr. Chairman, under I think the line of your questioning, not forgetting what the just role of the clerk is. We don't ask them to make determinations about what's a fraudulent deed and what's not. And that's where I'm trying to solve, what do we do with the document to keep the title from being clouded, but also not turn a clerk into an arbiter of a valid deed or not. And that's, I know you're working in good faith with them, working in good faith with you, and all of us here trying to work in good faith to try and, this is a problem.
Right.
And it's just trying to figure out how we get the solution outside of making someone come hire an attorney. I understand that. I want the mechanism too. I'm just trying to work with you to get there.
I think you just gave us some daylight there, and I think you have a very good point. I think under both scenarios, whether it's the deed having the note on the file or them holding it and not filing it at all, we're not asking the clerks to make any decisions. They're just operating this process. Even if they put it in a box, like the chairman judge here said that they were doing the rural areas like where I grew up, you know, it would sit there until the notice period ends. There's no decision by the clerks. Their job is to, under here, would be to just operate under the code of the law, which is if that period passed and no one has objected or anything of that nature, then the deed would go through. And if the person does object, then the individual who filed it, they would need to seek civil action if they want to enforce this, because we're being told it's fraudulent. And then they talked about the cross-reference there earlier. So we wanted to be absolutely clear and sure that this didn't put any decision-making responsibilities on the clerks, and there isn't any.
Okay. Representative Holcomb, is that you, number 2? Oh. Oh, you didn't mean to do that? Okay. Representative Hong?
Thank you, Chairman. Just to clarify, does this, I want to look into foreclosures. So when an individual buys foreclosed property, would they have to wait 45 days depending on who's doing the foreclosure if they weren't part of any of this notice? And
they're buying a foreclosed property, they're buying it through the bank, right?
Possibly. It could be an individual that is also doing a foreclosure because they individually finance the property.
So if it's an individual and they're selling their own property, then that is the owner. They're exempt. If it's the bank and they're doing the foreclosure, banks are exempt under this list. It wouldn't apply to either one of those.
On the waiver? Okay.
Yes, ma'am.
Thank you.
Thank you. Good question.
All right. See no more questions.
Mr. Chairman.
Yes.
On line 37, where it says the notice provided in subsection A, I think we were a little worried. I think it's Legislative Council has said that the notice and the 45-day period are being deemed to be the same, but I think from our perspective, we would love it if we could replace the word notice with 45-day waiting period and notice, just to clarify that.
And Mr. Chairman, we've talked about that. I have no issue with that change. I did go over that this morning with Attorney Carter when I got the call from Mr. Bridges about that exact language. And the way it was explained to me by Legislative Counsel is that when this line 37 referenced subsection A, that indeed includes the 45-day notice period, because that's what we're talking about. So by operation of code construction, it is included in that language. To make it clear, I don't mind. I don't have an issue doing that. Our Legislative Council people are pretty smart. I like to listen to what they say. So, but if it's better for us to change it, I don't have a problem. And I make that clear to Laurie and Mr. Bridges. I have no issue with that.
All right. Any other changes to the bill?
No, that will be the only one if we need to make that one.
Okay. Jeff, did you want to say anything?
I was going to speak.
Well, if you'll get to a mic, and then it's 17.
I was just going to speak to what Lori had presented on that concern about the clarity. I think without that, it's at best unclear, and I agree it may cover it with notice, but with that, it's more than clear that this is the 45-day waiting period and the notice.
Okay. All right.
And the other thing was, Representative had mentioned about the concerns about setting it in a box or setting it aside. Our concern was if nothing is at least noted on the record, I could go sell you a property, the next day I could sell it to someone else, the next day I could sell it to someone else, and by the time that 45 days is stretched, I've sold it 15 times and left town with millions. So.
Thank you, Jeff. Mr. Chairman, I apologize. Jeff, you're absolutely right. I forgot about that. The group was concerned, too, with not allowing continuous fraud, because we do see that fraud kind of happens in a quick pattern. So to prevent that person from being able to do it again within the 45-day period, they felt like a note on the file would help kind of, help title searchers see that
Okay. So
there's something happening here.
that would be the requirement of the filing then, not holding it.
Yes, sir.
Okay.
So that would be an operation of the clerk's office in actually filing it is what you're saying. Yes,
So,
Thank you, Jeff.
so okay. But the way it's worded, it says that it's, all right, the owner, I'm looking at line 33.
33, okay.
The owner or deed holder of record has 45 days from the date of the notice provided for in paragraph 1 of this subsection to notify the clerk of the Superior Court in writing by notarized affidavit sent by mail or affirmed in person that such recordation is unauthorized. All right. So it is of record at that point. It's not sitting in a box. And okay. I'm just trying to figure out what the original purpose was and what we're trying to get to.
We were part of the discussion to be certain the rest of real estate was carved out except for the fraudster. So essentially, if it's only the fraudster that's getting held, if there's a better way to do it, have somewhat of a provisional filing. I don't know that that's even a thing, but much better than the absence of something on the record, just to prevent that. If they're a fraudster, they're going to find a way to perpetuate that for the days it's in absentia,
Okay. All right. Just thinking.
Yeah.
Chairman Leverett.
So I think what we're going to be requiring our clerks to do then, every time a deed or any kind of instrument is filed, is they're going to have to ascertain the tax parcel of the property described in the legal description or parcels, and then they're going to have to check that to see who the current owner of record is, at least according to the tax digest, which itself may be delayed. And then if it's the owner, they can go ahead and record. If it's not, they give the 15 days unless one of the exceptions applies. Like if it's an attorney, they would generally not have to do this.
But they got to be looking for all that.
Yes, sir. So the exception, the exceptions and the carves out cover about 98% of the process. And with the way they come in right now through electronic filing, they instantly know this is coming from an attorney by the profile with the electronic filing. So we know who they're coming from. So it's not going to be as burdensome as them having to stop and go look somewhere. Some of this stuff is going to be streamlined by the system.
And by the exceptions.
And by the exceptions, yes, sir. Okay. So we talked about that too, Mr. Chairman, because the last thing we wanted to do was to cause a delay in the clerk's operation. And so we were able to work through that so that we're not doing it.
Okay. And this, I still don't think this takes care of the scenario you brought up with the recording. They sell it or whatever they do to it. Somebody comes in with a recording and then they do that day after day after day. I don't think this fixes anything on that. That's just
the note on the file is what would halt that, and that's why we came to the conversation of putting something on the file, so that it will be there.
Yeah, I see what you're trying to get
Yes,
to. Vice Chair Reeves?
I'm sorry I had a conflict and got here from another committee a little bit late. Have we talked about the PT 64 or PT 61 form yet? On that part, and I think the folks who file the deeds are well familiar with that. The paralegals and legal assistants, that's kind of a gatekeeper part of filing the deed, and there you've got to fish out that tax parcel at that stage for your PT 61 tax compliance. So that's a tax parcel step in the process. Don't know about. I know for quitclaim deed, warranty deed, and conveyance you do. Don't know about security deed.
Okay.
It wouldn't be applicable on security because while it is a conveyance, it's a conveyance of secured debt, so there's no consideration or gift that you have to declare in the transfer tax it and due on it. But I had not thought about that. You're right. On any deed, warranty deed, limited warranty deed, quitclaim deed, you're going to have that PT 61, so they wouldn't have to go through the process of ascertaining the tax parcel, and that would sort of take care of that step for them on most of your filing.
Yes, sir.
Okay.
So, Mr. Chairman, I appreciate the consideration of the committee here. As we stated, the intent here is to try to bring some relief to the people of Georgia who are finding their properties taken from them. My heart goes out to those seniors, as well as men and women trying to serve our country, and someone's over here committing fraud upon them, and now they have to shell out, sometimes thousands of dollars just to get their property back. I knew this bill wasn't going to be perfect, but I figured it would kind of give us a start to at least having a proactive measure on how we can help protect the people of Georgia. And I'm willing to continue this conversation as we move forward about how we make this better. But I think this at least give us a footing to get started.
Okay. Are you asking for a vote today?
I am asking for a vote today, yes, sir.
Okay. All right. I don't see any more questions, and I don't think we have anybody else to speak on it. So what's the will of the committee? I have a motion and a second. And leader registration.
Proposed amendment. This is Tom.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. On line 37, I'd ask to add after the word notice and waiting period.
Okay.
Second that amendment.
All right. Let's see. I have, is it Representative Kelly? Not you?
Possibly another amendment, Mr. Chairman, but nothing to add to the discussion on that, on this proposed amendment.
All
I
right,
may have another amendment later.
Now's the time. So
Okay,
if you have an amendment.
Okay. I was just wanting to make clear or ask the opinion of the committee whether we need some language that makes clear that this doesn't, if you missed a 45-day period, that it doesn't subvert any other right you have to seek redress. I don't want that to be used by a fraudster and say, well, you didn't respond in your 45 days.
Yeah.
I'm worried about that. I don't know exactly what that language looks like, but that's what I was kind of.
Okay, the First Amendment was, and waiting period had no limit on it. So is that right?
Yes, sir.
Okay.
We have I think his amendment references back up to the 45-day waiting period that we've talked about previously.
Up in A2.
Mm-hmm.
Yeah. Okay. Let's see. Who's got number 5 over here?
I do, but if, in response to Representative Kelly, I don't know if we wanted to finish Leader's amendment.
All right. Would you have an idea where that would be in the bill?
Probably you would have something, either a new section 5 and then renumber, or somewhere you could probably maybe amend it on into section 4 maybe.
I was wondering if you could just add to the end of line 36 that the failure to do whatever this says doesn't preclude any other remedies under law or something like that.
I think that's it.
I like that language.
All right, I hope somebody's getting the language down on how that's read.
Yeah. I'll try.
All right. So that'd be amendment number 2. All right. Any other amendments?
Has someone moved the Kelly
we-
Evans amendment?
No, they haven't.
I was trying to write it out.
I'll motion. I'll make that motion.
Do we
Second.
have a second? All right, have a motion and a second on the second amendment. Any others? All right, hearing none. On the first amendment, which is after the word notice on line 37 and waiting period. All those in favor say aye.
Aye.
Any opposed? All right. That's on. And then on the second one, and Representative Evans, I'm going to ask you for the language there. I didn't get it down.
Yep. This could be amended in a friendly fashion, I'm sure. There's one word in particular that I'm not fond of. The failure at the end of line 36, the failure to provide such information, and I don't know what else to call it, the failure to provide such information does not preclude any other remedy available under law. Shall not preclude.
The failure to act under this code does not.
There you go.
Okay. I'm sorry, Mr. Chairman, if I'm out of place.
The failure to act under this section shall not preclude any other remedy available under law.
Okay. Everybody understand the amendment? All right. All those in favor say aye.
Aye.
Any opposed? All right. So we have the two amendments. Or any further discussion on the bill itself as amended? All those in favor say aye.
Aye.
Any opposed? Okay. You got your bill.
Thank you, Mr. Chairman. Thank you, everyone.
Yeah. Did I lose Jones?
She's right there.
Oh, that Jones. Okay. All right. Tell you what, I'm gonna. We still got 5:55 to do. I'm gonna get Leverett, and then I'll come back to her. All right. So, Chairman Leverett, you ready to do House Bill 530?
Yes, Mr. Chairman. May I do it from here?
Yes, sir.
And I think we do have two witnesses who wish to testify to the bill, and we'll sort of take the committee through it in greater detail.
All right.
One Judge, how are you? I have Judge Wood from the Probate Court of Cherokee County, I believe. I hope I got the county right. And Kevin Holder, who's the director of the Probate Judges Council, is also here. This bill would basically authorize electronic filing in probate court as well, and would require judges to allow it or be ready to allow it by January 1 of 2028. The statute basically tracks the Superior Court statute, which I think is 15611. My memory did not serve me well at all there. And so it just simply tracks a lot of those same things. When the filing, when the system needs to be in place, what the vendor can charge for, what kinds of filings would not result in the imposition of a charge, and that sort of thing. So, I suppose just to put it simply, there's sort of a move for the same kind of convenience with respect to probate courts as well as we have in the Superior and State courts now, and so we'd like to just go ahead and try to get this passed this year so we can get everybody working toward that goal.
Any questions of the author? Judge, did you want to add anything?
It speaks for itself, but this is kind of the follow-up to last year's where we
rationalized our fees, for lack of a better term. It was all moving towards e-filing. So this is our kind of next step in that process.
Okay. All right, I don't see any questions. What's the will of the committee?
Motion to pass.
Second. All right, all those in favor say aye.
Aye.
All right, it passes. All right, any opposed? Let me ask that. All right, not hearing none, it passes.
Thank you, sir.
All right.
Thank you, Mr. Chairman, members of the committee.
Yes, sir.
That was a lot less painful than the fiduciary law section. I think we would all agree.
Absolutely. All right. Let's see. Representative Jones.
Thank you, Mr. Chairman and members of the committee. I have before you House Bill 545 LC number 481506. This bill was passed from your committee last year, and it passed the House. It went over to the Senate, came out of the committee, the Senate rules, and it made it to the last night, sine die. That's where it died. But this bill, the current statute as it relates to this bill, does not make it clear as to who the appellant makes the request for the transcripts with. In some courts, the request is made with the judge's staff attorneys or staff members. And the small change that we're asking for in this bill, as listed on lines 21 through 24, will allow the process to be the same in all the courts in Georgia. And I'm asking for your favorable consideration. And I have with me Dr. Vincent Terry, if there are any questions that he may be able to address.
All right. Does anyone have any questions on the bill? I think this is, like you said, this is the one we've seen before. Okay.
Correct.
All right. Do I hear a motion?
Move to pass.
All right. Got a motion and a second. All those in favor say aye. Aye. Any opposed? All right. You got your bill.
Thank you.
All right. I'd like to know where Trey Kelly. You got 555?
Yes, sir.
Okay. Come on up. And we're getting close to the end, folks, so just so you know.
Thank you, Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman, for hearing my bill, and thank you for committee meetings. I kind of got PTSD because last time I was in front of non-civil with my first bill, I still have the scars from road rash. So, and that's just tough.
Oh, that's non-civil. We're a lot.
Okay, we're a lot easier over here. Oh, good. Yeah, you're civil. Well, so we're working off of LC 550493. So I'm going to kind of tell a little story. This bill essentially is about, it's obviously named Georgia First Residential Property Protection Act, but essentially what's happening in Georgia and across the country is these private equity groups in Wall Street are literally buying up all of our single family housing. And, the America is built on the middle class. Everything that the middle class has done from coming from home from World War II, they bought houses and built equity, and that's how the middle class has built equity. And they've sent their kids to schools and bought cars and things like that. So the middle class, if we let these hedge funds continue buying up all the single family housing in America and Georgia, we're going to completely wipe out the middle class. So the bill is, it's actually several things. So when these private equity groups come in and buy a house in a subdivision, they're overpaying because money is nothing to them. when you've got, some of these companies have $1 trillion in assets and holdings. BlackRock is they're on $11.7 trillion, which is the size of Japan and Germany's GDP put together. So these companies, I'm for capitalism, but these companies have their thumb on the scale. There's no possible way that our kids can compete with them. They'll come in and offer offer $50,000 over asking and close in 15 days. These younger generations, they can't buy these houses. You can't compete with that. So not only that, also we're trying to fix a tax issue with our property taxes on these houses. And what's happening is these companies are coming in and they're buying a house in your neighborhood and they're paying $50,000 over asking. Well, guess what the tax assessor is going to do? They're going to use that house as a comp, and everybody's taxes in that area is going to be, that's the comp, and it's going to go up to that. That's what's increasing our taxes in Georgia, is these companies coming in and overpaying for these houses. So what they're doing, I've got some numbers. Georgia is actually the #1 on the hit list in the United States for these companies buying up these houses. Innovative Homes, I've got some numbers. They own 14,000. Now this is what they actually show. If they could have entities that they have pieces of and they own even more than this, but they own 12. Sorry, let me pull it up. Put my eyes on. So in 2023, Invitation Homes owns 12,752 homes in Atlanta. That's not in Georgia, that's in Atlanta. And those houses will never, ever be fee simple again. They're going to be rental from now on because they're just going to sell them to another hedge fund when they turn these properties. And a lot of these properties, they just let sit empty. And they just take the tax off of them. They just sit there, and because they're parking their money in something that always is going to increase. Property is always going to increase, so they just park their money in that vehicle. Whether it's empty or not, they really don't care. So Blackstone, this is an article I found. Blackstone owns 61,964 houses that they actually show. Now they can own entities for other houses. They own another company, Progress Residential. They own 83,000. Did I say 61,000? Yeah, 83,000 homes, and that's the second place portfolio. So all these companies are building these subdivisions. A lot of them are 100% rental subdivisions. They're buying houses in these residential areas. Not only that, they're also buying single-family housing. They're also buying apartments. So they're building all these apartments and owning them. They just lost a lawsuit for these these hedge funds, and essentially what they were doing is they were using the same software, which all these companies own a piece of each other, and they said it was an accident. Attorney General sued them, and they were price fixing because they were using the same software across all these apartments, and they knew exactly what all of them was charging. So they're price fixing these rents. Look, I own rental houses, right? And I'm not against rental, but these companies have, like I said, they have their thumb on the scale. But so anyway, let's get into the bill. That's kind of the gist of it. So what we're doing here is we're limiting. I went through this bill, I thought through it and worked with Edge Council. I've been thinking about this for 2 years. Me and Martin Monahan have talked about this. I know Martin's got some stuff as well. So we're limiting business enterprises from owning interest in 2,000 single-family residential houses in Georgia. So the interest piece is very important because what they're doing is they own pieces. So they'll say we only owe, just say a number, 10,000. We only own 10,000 houses. Yeah, but they own this other company they own half of that owns 40,000, and it's et cetera, like, tell a friend. So so that's the big piece is interest. And then we're limiting them to 2,000 single family houses in Georgia. and then 10 multifamily apartment complexes. So that would mean they own, it could be 1,000 units, but that'll be one complex. So we're limited to 10. And essentially what we're doing, if you go through the bill, we're just making it that that's the number that they can own. And then we put in here, essentially Attorney General, or our Attorney General can go after them, and, keep them honest, per se. They have 2 years to, sell off the houses that they have over and above 2,000 houses or 10 apartment complexes. They have it'll be $15,000 on line 75, $15,000 per violation if they get caught, fudging the system. And obviously, they'll be able to figure out who owns what in discovery. And then also, we have a 4-year statutory on here. So after 4 years, it'll be limited as far as that goes. But everything else is just pretty much cut and dry. I'll appreciate you listening to my rant, and I'll stand for any questions, and I ask for your considerable vote of yes.
Okay. All right, Representative Hong.
Oh, I think that's me, Mr. Chairman.
Oh, I'm sorry.
Well, yeah, I'm not going to be able to live up to that name in wits or beauty, but I will try to give some commentary here on House Bill 555. First of all, Representative, thank you for bringing this bill. As you know, this is an issue that I've been working on myself. In Paulding County specifically, we have had these hedge funds who have come in and bought thousands, not dozens of thousands of homes to rent. And with all sorts of implications federally, with housing vouchers and trying to control area average rents. And that's been an issue that we found, raising the pricing of housing in much of a nefarious manner. So we've seen BlackRock and all these others do that. Isn't it true that you've also found through your research, and I think we've discussed this in the past, that there are foreign adversaries that are actually purchasing land, not land, but these homes to rent to also control rental markets and pricing of these rental markets?
Well, that's a great point. I mean, if you think about BlackRock and they're worth $11.7 trillion, we have no idea who their investor is and who they're actually holding the money for. So essentially, I mean, obviously land is our biggest natural resource here in Georgia, even if it is privately owned land. So if we have no idea who's buying it. It could be all China buying up all this land, or any of our adversaries, Russia or anyone else. So, but yes, to your point, that is 100% correct, and thank you for that.
Has it been your opinion that this price fixing has to do with the business model? And I think you testified to that today. And when I say that, I mean to say that a commercial endeavor is much different than, let's say, a private local investor. You're dealing with, a capitalization rate maybe 6 or 7%. They know that as long as they can return that to their investors, they can really edge these prices up to a point where few can really afford the homes to rent them. It also raises the overall pricing of the homes in the area, sometimes putting them out of reach for folks who have just got out of a trade school or a young small family. Is that kind of what you're telling me here? Is that true?
Yeah, yes, I've actually had constituents. I mean, I've had a lot of constituents. I've actually had some interns out in the halls come and shake my hand and thank me for this bill, because, like you said, it is making owning a home almost impossible in Georgia. Our kids will not be able to buy a house if we don't help them, and the only way it's just out of touch. I mean, we got attorneys in this building, and I know of several specifically that's come to me and says, I can't buy a house. I'll put a house in a contract and a private equity group come and buy it out from under me. And you can't, like I said, I'm for capitalism, but you can't compete with somebody like that. This is not possible. So to answer your question, yes. And look, I'm not against private equity groups. I'm not against Wall Street. there's a place for that. I get that. I mean, we use them for road projects and skyscrapers and things like that. I'm just asking, they do not need to be in the single-family housing business because they are going to kill our middle class. Because if you look in the past, back in the past, there was rich people and poor people, and those poor people were renting houses, and they were called sharecroppers. And that's exactly what we're going to go back to. If you look at the UK, the only people that owns houses in the UK are the Crown and private equity groups, and they might be a few that's got their houses passed down to them, but it's very rare. That's why they're socialist. So, to answer your question, I'm sorry that went long, but
thank you. And Mr. Chairman, if you indulge me on one more question I have, and that is, you had talked about, home ownership as being the greatest wealth generator that really, I think, even worldwide, as you just spoke to, has ever seen. Isn't that more so for minority groups in our state? Isn't it true that home ownership is the greatest wealth generator for minorities?
Yes, it is, and actually, to your point, they are actually preying on minorities as well because of that point. And I've had constituents call, and I've talked to people in Fulton County, and actually some of these articles actually specifically talk about Fulton County. What these hedge funds are doing is they manage these properties in Arizona and out New York and places like that. So they prey on these people. They can't find a house, and they rent them these houses, and then they just bombard them with fees. Like they might have, fee after fee, and even though a lot of these fees are illegal, they're still charging them, and they'll ruin their credit. They won't be able to buy them. And I talked to one of my constituents, and they rented a house, stayed there a year, were going to buy it, move out, and they come back and said, obviously people don't, they're desperate, so they don't read these contracts. So they didn't read the contract, said you had to give them 30-day notice, so they charged them another fee on top of their deposit, and then charged them all these other fees for paint and stuff like that. So they're just predatory. So thank you. Yes.
Okay. Vice Chair Reeves.
Two questions, Mr. Chairman, for the author. Have you seen these large mass companies ignoring homeowner association and code compliance, government action on the maintenance of the properties?
Yes, GMA and ACCG have talked about this nonstop about, and there again, what happens is these companies come in, they'll buy a house, leave it set and empty because they're just using it as a vehicle to park their money. And these cities and counties and HOAs will reach out, and they don't even know who to contact, and they don't respond. So you got these blighted properties, nobody knows who even owns them.
And second question, Mr. Chair, for the author, I'm sorry I didn't find anything. I think Georgia may have to be a leader on this, but you and I have talked about antitrust. A lot of the terminology you've used and members of this community have used fits into federal antitrust and other legal definitions of antitrust. And whether it's in this bill or a separate action, I think federal and state action under antitrust to bring down some lay down the law on these companies who are acting like they're above the law, I think is a good idea.
I agree. I beg our federal government to step in and do antitrust on these private equity groups, as we've done in the past in history, if you know your history. So, but yes, thank you, and we'll keep plugging away. And I think we need to be the leader. And actually, Governor Abbott actually has been a leader, and he's passed something similar to this, or they've got very close.
Okay. Is that you? Okay. 18. Representative Deloach.
I'm aware that there are some large national companies whose business model is to use federal tax credits to build multifamily affordable housing units. And the way they operate, they build those units themselves and they operate them until they get very high occupancy rates, close to 100%. And they continue to operate them until that market is such that they decide to sell them. So they might at times have 15 or 20 multifamily units, and then when the market gets good, they sell them off and go build some more. So there's an up and down curve there, and I just wonder if this would impact those people that are working to build and operate these affordable housing units.
Well, I'm not going to, disagree with you, but I think that we can have that same thing with Georgia companies and Georgia-based companies. But I'm not cutting out that they can do that still. I mean, it has in here, they can build 10 of those units, and I'm not trying to make it impossible, but we already are. I mean, it is already impossible. Look at how many homeless people we have already. So yeah, I think there's affordable housing need, but these companies, like I said, they're definitely predatory. But thank you for the question.
Thank you.
All right, I don't see any more questions from the committee. Anybody? I see 2 hands back here. Hayden, you want to come up? It might be easier if you get on this side over here.
I'd love to just stand behind this pole. Mr. Chairman, members of the committee, my name is Hayden Stanley. Our firm represents the Georgia Apartment Association. Very proud to do that and have for many years. Representative McCollum and I have had conversations about this, and our client and Representative McCollum, as you might expect, see things differently. In terms of the impact on the financial structure of the way apartment communities, properties, and housing is structured in the country and in this state, this bill would be devastating. It would upset. I can't even go deep enough on the impact of this. So you've covered a lot of points today, and I respect that, and certainly our members do. But again, just to get on record today that the Georgia Apartment Association opposes this bill, and specifically the inclusion of apartment properties.
Okay. All right.
Thank you.
And Jeff, you want to come up?
Sure. Mr. Chairman, members of the committee, Jeff Ledford with the Georgia Realtors. Really, I guess to unpack a few things here. The first thing is that anytime we are restricting who is allowed to own property, we are going to, at that point, have concerns. I think as described this morning, there's a lot of anecdotal comments that were made about who might be owning it and so forth. You can have an ugly target. It's easy to go for, but this sets a precedent of establishing where the state says who and how much property anyone can own. Whether it's a corporation, that could then go to individuals. There's a history we don't want to repeat in that. Moving from that, one of the core problems I see in this is that you've capped a corporation from owning. There's nothing that prevents, especially if you look at how the real estate investment trusts are formed. And I know there were several of the investment entities out there referenced. Most of them do not own the house. They own a portion of another investment. And so if I wanted to get around this, I'd simply set up more corporations and invest in them. If I'm capped at $20,000, great. I'll just split my company into 2 separate entities, invest proceeds that way. If I'm a portion owner of many, which is how many of these are structured, then that would be the workaround on this. As far as, and I also want to be clear, I'm not here to defend the institutional investors. We do have some ideas of ways that we could approach this as a regulatory approach rather than a cap on the free market. If you are having a forced sale, so in other words, if this were to be implemented and you had a mass sell-off of properties in the 2-year time span, that could be extremely devastating to the market. It would be an artificial injection of an oversupply. Right now, we're in extreme undersupply. I would say it's very easy to look at this and say investors are coming in and raising the rental rates. We're not seeing that. Our chief economist has spoken to this several times as well. It is rents are rising because there's a gross undersupply in our state, 100,000 units in Atlanta alone. So it's as if I would think of it, rather than we're pulling the rates up, instead there's a wave and it's rising. And these companies see that and there's money to be made, so they come in and ride the wave. They're not moving in and forcing a new market. The market's there.
Okay.
And
All
I'm
right.
happy to take any questions about what I may be able to speak to.
There are some questions.
Sure.
Representative Oliver.
Mr. Chairman, as you know, there's a hearing this afternoon in Government Affairs with 4 other bills in relation to these issues of out-of-state hedge fund or investors. And Mr. Ledford and I have been talking about this, and Mr. McCollum and I have been talking. Are you aware that I put on the desk yesterday a piece of literature from the AJC last week in relation to 3 children dying in South Atlanta in a fire?
I'm not aware that you put that on the desk, but I'm aware of some of the problems, and I think there's a lot that can be done to address these issues.
This complex website says that the property is managed by Capital Realty Group, a New York-based private equity real estate firm that focuses on affordable housing. Country Oaks apartment is among 272 Metro's persistently dangerous complexes. 153 crimes at this address. Homicide in 2017, 66 aggravated assaults, 5 robberies. This is the kind of data that my constituents are reading in the paper every day, and this complex would not respond to any questions posed to them, whoever Capital Country Oaks property management firm from New York investor group is. Tell me how we solve this.
I think the simplest way, right now you have a lot of these entities, they own the properties. Under 4340-29A, an entity is allowed to run their own, or have an employee manage their properties. Other than that, you're required to be licensed under Chapter 40 of Title 43, sorry. What does that mean? Why is that important? You can't locate them. You can't find them. You don't know who they are, and they're not subject to the rules and regulations that are in place in this state for management of properties. If that were someone that held a license, one, you would, in the lease agreements, you'd have their information. You'd know their license number. You'd know who they were. If you couldn't find them, under 4349, you could legally serve the real estate commissioner. The real estate commissioner, currently Lynn Dempsey, could receive service on that. Proceedings could move forward, and that is for any judicial or real estate commission administrative hearing. So there's a lot of recourse. There are also regulations that they must be competent and adhere to. In Title 44 landlord-tenant regulations, it would comply. In brokerage and real estate transactions under Title 10-6A, and under Title 43, Section 40, the 25, and many other areas. Also covers the brokerage accounts they must maintain. So if someone is not handling those accounts properly, before you are allowed to even begin, you're required to grant access to those accounts for oversight to the Real Estate Commission. That comes under 4340-22. So there's a lot of steps that are already in place. That one little component that's missing is that exemption to licensure.
Mr. Chairman, I wanted, that was helpful. I wanted you and the committee to know that this is being discussed as it, in the concepts of, it's not a cap for some of the issues. The concept is accountability. Who do you call when 3 children are dead and there's hundreds of violations of the complex? Who do you call?
Right.
Mr. Chairman, if I may.
You may.
So, to his point, if you look at line 3 of the bill, it says enterprises from owning an interest. So, to his point, if they own any interest in the companies, they would be covered. And obviously, it's a private attorney general in the bill that would go after these bad actors. And then also, I've had numerous realtors calling me and talking to me about they literally have nothing to sell because these companies are circumventing the realtors. They're starving because they're in Arizona. They're calling these people that live in these houses directly. They cut the realtor totally out. They buy it directly from them. And the management companies are not even in Georgia. They're outside of Georgia. And I understand what he's saying, But I've been working on this for 2 years, and everybody wants to talk about how they're going to fix something, but nobody ever helps me come up with an idea. And this right here is something that we can do right now. If we need to change it, we can change it. But this stops these bad actors. But in the past, in America, we've broke up these companies and stopped them from doing things like that. And I understand, I'm for property rights, but for us just to continue to sit on our hands and let these companies completely buy up our state and our country and totally wipe out the middle class and not let anybody buy houses, if what he's saying, if these companies by 2030 they own 60% of houses in America and they're all rentals, the realtors are going to be out of business because there's nothing going to be sold because it's going to be all rental owned by these companies. Okay. Thank you, Mr. Chairman.
All right. This will be hearing only today, and this will be the end. I have no more questions and no more speakers. So,
thank you.
We are adjourned. Hey, everybody. Hey. Everybody, we have lunch coming here. So we have lunch. Yeah, we got caucus upstairs too. So. I hope it is.